And perhaps, okay, perfect. So welcome everyone, and I see people are still joining us. Thanks for being here with us today. We are starting now with our seminar. I will repeat that this meeting is being recorded and will be posted later on onto the website of the Wageningen University Law Group. Thanks for joining us. This seminar is part of a series of webinars that the Law Group of the Wageningen University organizes. In this case, sorry, I'm still admitting new participants. In this case, the seminar is organized in collaboration with, sorry, can you mute yourselves when you join? Thanks. In this case, the seminar is organized in collaboration with the Nova Law School based in Lisbon and with the Teaching Business and Human Rights Forum. And we are very happy to have three distinguished speakers who will help us discuss and debate the newly published proposal of the European Commission for a directive on corporate sustainability due diligence. In the meantime, many of my colleagues who are helping me admit the participants. And I will just briefly introduce the three speakers. I'm sure most of you already know them. We have Claire Bright, who is Associate Professor in Private Law, as well as the founder and director of the Nova Center on Business, Human Rights and the Environment at Nova Law School in Lisbon. And then Nicolas Bueno, who is Assistant Professor at the French-speaking Faculty of Law of Unidistance, Swiss. And finally, Nadia Bernas, Associate Professor at the Law Group, Wageningen University. And I am Chiara Macchi, a lecturer at the Law Group of the Wageningen University. As you might know, we all work in the field of business and human rights. So as many of you, we were really eager to finally see the proposal for the Directive on Corporate Sustainability Due Diligence that has been published just a few days ago, and that has already sparked quite an amount of debate and discussion. So I will just tell you how today's webinar is going to be managed. We will have, first of all, a couple of rounds of questions for our speakers, in which we will discuss the positive and the potentially critical aspects of the Commission's proposal. And then after these 2 or 3 rounds of questions that I will ask the speakers, we will open the floor to your questions, to questions from the floor. So without further ado, I would like to dive into our theme. And I would like to start from discussing with the speakers the relevance of this proposal. And in particular, what are, in your opinion, and I'm asking all three of you, what are the most important positive features of the draft directive? In what ways, in other words, it met your expectations? And what do you think is the importance of finally having a piece of legislation at the European Union level on mandatory human rights and environmental due diligence? I will give the floor to Claire first, and then I will give the floor to Nicolas and Nadia. Claire, you have the floor.
Thank you so much, Chiara, and thank you for the opportunity to co-organize this event. It's a pleasure to be here. Hello, everyone. So there are many positive aspects of finally having a text on corporate sustainability due diligence tabled by the European Commission. I would just like to briefly highlight 3 key points which, in my opinion, are particularly positive about the directive, the proposed directive, shall I say. First of all, the holistic approach. So we have a directive that embraces both human rights and environmental due diligence. And of course, we've seen important developments in the field recently, and an increased recognition of the human rights implications of corporate environmental damage and adverse impacts. Yet in practice, what we do see in corporate conduct is that these issues of human rights impacts and environmental impacts tend to be treated completely separately, often by different departments, different services within company. And what is lacking is really a holistic approach. So I very welcome the sort of call from the proposal to have and embrace that approach. The second point would be the way due diligence is understood, which is as a standard of care, a standard of expected conduct from a reasonable company, which is very much in line with the way it is envisaged in the UN Guiding Principles on Business and Human Rights, needs to be evaluated on the circumstances of the case and necessarily is context specific. This is important because it is can be opposed to contrasted with due diligence understood as a sort of tick box exercise, as a procedural approach to due diligence, which would lead to cosmetic compliance. And then finally, very briefly, for me, one of the key points and the key positive points of the directive is that it contains a civil liability provision, which is essential for ensuring access to remedy. We will have a chance to talk about it later. I'm not saying necessarily that it's perfect, but there is a civil liability provision, and that really places the people in the center to ensure that affected, or to help at least improve access to remedy for affected individual. And I think that's really key.
Many thanks, Claire. Nicolas?
Well, thank you, Chiara, for the organization. Hi, everybody. It's I'm very happy to be here to discuss about this draft directive by the Commission. Well, I think the first good point I want to emphasize is really the good signal that the European Union is giving us with this draft directive. As we have now passed the age or the era of only corporate disclosure, transparency, we're now moving into a direction where we have more concrete examples and guidelines and requirements for what is due diligence. I think companies are getting more and more used to it, and I think this is a good signal from the European Union. Not only talking about Green Deal, about sustainability, but actually taking action now with this directive. So I think this is a very general and positive signal for the way business will be conducted in the future, and very general. Now, the second aspect, I think, is harmonization. We've discussed in the past decade now about national legislation. I come from Switzerland. We had this debate for several years, and always the argument was, well, we want to do something, but Switzerland is a small country, although with some quite big economy in relation to the population, but still we're not able to, we are scared about imposing new obligations on companies. And I think this harmonization that is taking place now in the European Union is a push for many countries that now will be less scared to adopt these kind of new legislation. So another very positive aspect. And I think a third, more technical aspect, I think we can debate this. For sure, there are some criticism that we can have regarding this draft directive, and we'll talk about this. But for me, or as well, in the discussion that we had on this mandatory human rights and environmental due diligence was, okay, but what is really human rights risk? And I think what is an environmental risk, what companies really have to do. And I think with this directive, we now have a quite clear way with an annex, and we can discuss it, that gives us very clear examples of what kind of human rights must be identified and remedied. And I think that gives us some clarity. We can discuss about the scope of these human rights and environmental rights that are identified in the draft directive, in the annex. But I think this provides very much more clarity, and companies start becoming more and more aware of human rights and environmental risks. So I think this is a very good move in the right direction. So very positive about this development in the EU.
Many thanks, Nicholas. And Nadia, you now have the floor.
Thank you, and thank you everybody for being here. It's nice to see lots of people joining us. So the positive features for me of this proposal is, first of all, that we have one. I think we've been waiting for this for a very long time. It's been promised and delayed, etc. I think it's worth recalling that. I also want to say that to even have a proposal coming from the Commission is definitely the result of a massive mobilization by civil society organizations and political parties also in the European Parliament. This is just remarkable. I think if you also look at what happened in France before the adoption of the vigilance law, the duty of vigilance law, we also had a success story basically coming from a strong mobilization from civil society and parliamentarians. So this is remarkable. And I also want to recall that human rights due diligence, now human rights and environmental due diligence, is a concept that was included in the UN guiding principles. It's a concept that's merely 10 years old. It's one aspect of the UNGPs. It's just one part of it. For some reason, it's an aspect that has inspired civil society organizations that have seen the transformative potential of this concept. But it wasn't meant to be, I think. I think it's really the result of a strong mobilization, a lot of activity of explaining what the potential of this concept. So I just want to say that it is remarkable to have that in 10 years, basically, since the adoption of the UN guiding principles. This is, of course, as far as the EU is concerned, also the result of the mobilization of the Finnish presidency in 2019, because since 2019 and the work they've done on this, we've been talking about due diligence non-stop almost. That's how it feels like anyway to me. So I'm really happy to see that coming through. Of course, as was mentioned, this is a proposal. We're still far from having a directive, and we're still far from having a transposition in member states. So this is still pretty much still the beginning of the journey, but some way we've gone a long way, I think, already. Just like Nicholas, I want to point out that this really shows something important, which is that we're leaving transparency only initiatives, this approach of transparency only behind. I mean, if you compare this text with the EU non-financial reporting directive of 2014, which is not that long ago, the contrast is really striking. We've really moved away from reporting alone. And I think this is very important also for business and human rights generally, because this idea that these issues can be dealt with in reports, in annual reports, without any change in operations, remains, I think, relatively established, at least in certain minds. So this is an important signal that we're really moving away from this. So I think as we prepare to tear this proposal apart in the rest of the seminar, I just wanted to make the point that for me it is a big deal that we have it, and it is an important development.
Many thanks, Nadia. And indeed, we are going now to dissect the proposal by looking at some of its key features, and in particular, carrying out a critical reflection on some issues that have already sparked quite some degree of debate, in particular the scope of the directive, the challenges of ensuring compliance, the definition of supply chain relationships, and so on. So I would like to give you the possibility now to highlight some of the main criticalities that you have highlighted in your, let's say, first reading of the proposal. So I will go back to Claire now for her initial remarks on this.
Thank you, Chiara. Perhaps a starting point concerns the scope of application of the directive, which is a very contentious issue. The directive, or the proposed directive, applies to large and even very large companies. More specifically, it is meant to cover European companies with more than 500 employees on average, and a worldwide net turnover exceeding 150 million euros in the previous financial year. And then after a transition period of 2 years, it will also then extend to mid-cap companies in so-called high-impact sectors that are impact sectors that include textile, footwear, clothing, agriculture, extraction of minerals, etc., which will then cover companies that have more than 250 employees on average, and a net worldwide turnover exceeding 40 million euros. And 50% of that net turnover needs to be generated in one or more of these high impact sectors. So what we see is that small and medium enterprises are excluded from the direct scope of the directive. And of course, this has been the object of many criticisms, because small and medium enterprises, as we know, constitute 99% of all companies in Europe. So, of course, the question that arises, can 1% of companies make a difference? Now, ideally, of course, we would have a proposed directive that would apply to all companies in line with the UN guiding principles on business and human rights, which, of course, clarify that the corporate responsibility to respect and the correlated due diligence expectations apply to all companies, regardless of their size, whilst allowing certain degree of proportionality in what is expected from companies. However, we also know that these types of laws are always the result of a political compromise. Nadia was talking about the French law earlier. We know that the original version of the French duty of vigilance law had a much wider scope than the one that was eventually, the version that was eventually adopted, which we estimate applied to somewhere between 230 and 250 companies, which of course is a very small number. However, I do want to highlight the fact that despite the fact that SMEs are not directly in the scope of the directive, examples of experience like the French duty of vigilance law really shows that these type of laws that only apply to large companies do have trickle-down effect down the supply chains and to small and medium enterprises that supply larger companies that are in scope. And so, for instance, there is one study that was carried out by PwC, amongst others, which showed that 80% of SMEs in France that are supplying larger companies that are in scope of the law, the duty of vigilance law, have been required by these larger companies to put in place due diligence processes, or certain due diligence measures at least. So what we do see is that indirectly a vast majority of small and medium enterprises that are the business partners or of the large companies that are in scope of the directive and are somewhere in their value chain will necessarily be also impacted and be required to do some due diligence. So there is some hope that there will be effects and impacts way beyond just the companies that are in scope. There is also a very interesting point of the scope of application of the directive, which again is different from over examples, especially in the French and the German example of existing laws, which tend to focus on companies that are registered or have a branch in the respective countries, in that it also, the proposed directive also extend to third country companies. And here I will pass the floor to Nicolas, because I know you wanted to speak about that as well.
Yes, thank you, Claire. Well, I agree with you, and I think maybe most of us agree probably that's the problematic, one of the problematic of this draft directive is obviously the personal scope of the directive, which will focus only on very large. So these are the new words that we use now, like very large company and large companies. Here is just a focus on third country companies. As you said, Claire, what is quite interesting is that this draft directive will apply as well to companies that are registered outside the EU, and I think this is something completely new. This is something we should pay attention of, I think, because they will raise some difficulties, but this start from a very legitimate question or argument that the EU countries said, well, okay, if we impose some obligation on sustainability, we think that this is the correct way to go for our companies to follow certain sustainability standards that are universally based on universal standards. And this is also a critique that we had sometimes that I've read in the annex that identified the human rights that companies will have to respect. Was, well, there is no convention, there is no mention about the European Convention of Human Rights, for example, that goes a bit further than the universal standards. But here, let us remind that we have a draft directive that aims to apply universally. So the human rights and environmental standards that we have to apply must be universal. This is why you have in the annex mostly a list of human rights that are based on the Universal Declaration on Human Rights. But now, so how will these human rights standards apply to third country companies? Well, first, there are as well this distinction between very large companies outside the EU that have a turnover of over 100 million euros in the EU will be subject to the law, as well as large companies, but only in high impact sectors, as you mentioned, Claire. These are only three: textile, agriculture, and minerals, if you want to summarize them. Another very problematic, I think, in this law with regard to the personal scope, and this is for EU companies as well as third country companies, is the exclusion of the financial sector in many ways in the directive. First, the OECD has also guidelines on financial undertakings, due diligence for their human rights due diligence for financial undertakings, which is also a high impact sector that has not been included in the directive. And I think this is important to emphasize this. And beyond these, companies in the EU and in third country companies that are financial undertakings have special regulations, special rules with regard to due diligence as well, if you take Article 6, paragraph 3. So this is another aspect. But now more specifically on these third country companies. Well, so this is legitimate. The EU want to impose to say, well, if you do business in the EU, you have to respect the standard. But now we have the question of the enforcement. How will that really apply in practice? So what is foreseen in the draft directive is that companies outside the EU will have to designate and establish an authorized representative. So someone or a company that will represent the company and that will have to be established in the EU. And that authorized representative will have to cooperate with the so-called supervisory authorities that each member state will have to implement according to the draft directive to ensure that the companies respect due diligence obligations. So this is the public enforcement aspect of this. Now there are several questions that we can ask with regard to enforcement of third country companies, how will, for example, these supervisory authorities have the power, will have the power to investigate probably at the headquarter in one member state. So how will this investigation will take place in the headquarters of companies that are outside the EU? This is a bit complicated to understand how will that work. Sanctions, will these national authorities will be able to impose some sanctions on the third country companies that have an obligation on due diligence? How will that really be enforceable? And finally, the question of civil liability, how will that be possible to sue a company outside based on civil liability that is in the national legislation of the EU member states? So many questions. So the idea is quite interesting to establish, okay, member states, third countries companies will have as well to respect these due diligence obligations. But I think we need to think more about the enforcement mechanism for these third country companies if we really want to level the playing field with regard to this directive. So
many thanks, Nicola.
Yes.
Thanks. Then I will give the floor to Nadia now for her remarks.
Yeah, thank you. Right, so I'm going to talk about one aspect of the proposal, and that is the concept of established business relationship. So let me explain a little bit, and it's in line also with the first point I made in the first round. We have a proposed instrument that if adopted, this instrument will lead to binding law in the EU, and it's going to be binding law that talks about companies taking responsibility for their own operations, for the operations of their subsidiaries, and for their value chain operations carried out by, and the term that is used is established business relationships. So I, first of all, again, want to take a minute to appreciate this, because that we know that what we are up against with these kind of legislations is economic relations that are based on the principle of separate legal personalities between legal entities, meaning that a parent company and a subsidiary are two different entities. We know the issues around liability that come out of this basic principle of law, even more so when you talk about relationships with contractors and subcontractors, etc. I mean, the starting point of all this is that a company is not responsible for the activities of others. So I just want to point out here that what we're talking about in this proposed directive is attacking a little bit this very well established principle. Of course, it doesn't end it, but it is, let's say, introducing the idea that companies cannot establish subsidiaries in foreign countries, cannot source from cheap labor countries without having some accountability attached to that particular, to these particular operations. And that is important. If you look at how the debates around this existed just 20 years ago even, this is very different. This is going quite far. This idea is going quite far. Now, is this how established patterns of capitalist exploitation end? No, it isn't, of course, but it is still quite a significant step forward to see the EU Commission actually propose a directive that recognizes this idea that European companies have a responsibility for global human rights impact beyond their own operations. I think this is really important. So going more in detail now into this question of established business relationship. So first of all, the formulation is very similar to the French, the formulation in the French duty of vigilance law, which talks about relations commerciales établies, so established business relationship. So it's a very similar formulation, and this, of course, can be criticized and is problematic, I think, in the sense that it certainly is not in line with the idea of the UN guiding principles, which do not restrict this responsibility to established business relationships, but talks instead of the corporate responsibility to respect human rights if the company is linked to certain human rights abuse. So the restriction to established business relationship, which is explained in the text of the proposed directive. I'm not going to go in detail over this, but basically there are some, to define this concept of established, there are some criteria when it comes to the length of the relationship, like how long has the relationship been going on, with regards to how, with regards to whether the relationship is expected to continue or is it just a one-off relationship. So these kind of issues are explained. I don't think everything is clarified in the text, but there is some effort to explain that particular notion. I don't know if it will solve all the issues. I do recall that this is a particularly problematic aspect in the French law that still hasn't been tested in court specifically. So it's still, I think, a concept that is that will probably evolve throughout the years. But in any case, it is the proposed directive really restricts those relationships to established business relationships. That, to me, of course, will make it easier for companies to comply with the directive or with the legislation that will implement the directive, because of course, when the company do this scoping exercise of looking at their relationships, looking at their operations to identify their risks, it's much easier to do that if you can just have a reliable list of business relationships of other companies that the company is dealing with on a regular basis. So it is, of course, from a practical perspective, I can imagine that if you're sitting in a corporate office trying to do this job with your team, that it's much easier if you only have to look at established business relationships. From the perspective of rights holders, however, it makes no difference whether the company is in an established relationship or whether it's just a one-off. And here I want to mention the Rana Plaza disaster. And we know that some of the business relationships between European companies and the company that was for which the workers of the Rana Plaza building were working, they were actually not established relationships. Some of them were just one-off contracts, one-off deals that led to that linked this company to European companies. So in other words, in the context of the Rana Plaza disaster, this kind of formulation would have excluded basically rights holders and victims and survivors of the Rana Plaza disaster. That would have excluded them from bringing claims, which is problematic, obviously. So I don't know if there's a solution to this. Obviously, I understand the difficulties for companies to do this work beyond established relationships, but certainly from the perspective of right holders, this is I think is a problem, and I just hope this won't lead companies to just constantly change suppliers or reform themselves in different forms to sort of evade the law. Maybe I'm a bit cynical there. I'd like to think that the effort it would take to do that is probably not worth it, considering the risk of claims in the end. And we all know this will be difficult. I think we'll talk about that in the next round. But it's a little bit a concern of mine that that this could lead to this kind of abuse. Maybe people in the audience will have ideas about that and can intervene in the Q&A around this issue. That's one of my concerns. I'll leave it at that for now.
Many thanks, Nadia. And actually, perhaps we can elaborate a bit more on this focus on the rights holders and look more specifically at, first of all, at the enforcement mechanisms foreseen in the proposal, but then also at the issue of civil liability to see how the Commission's proposal address this aspect that has been considered as one of the most crucial aspects throughout the process of discussion that has taken place in the last few years. We have seen how the European Parliament had tackled the issue. And now I would like to know from Nicolas, first of all, how do you assess the approach that has been chosen by the Commission in relation to enforcement and civil liability?
Thank you, Chiara. Well, first, maybe just an overview. There are two main ways of enforcement that are in this draft directive. The first is the public enforcement mechanism, and the other is civil liability. I think I will be more descriptive on the public enforcement and more critical with the civil liability. So the main idea with this public enforcement is that each member state will have to establish a supervisory authority that will have then to make sure that the company respect their due diligence obligations as defined in Article 5 to 11, I think, of the draft proposal. So this is quite based on the German idea of public enforcement, and I'm sure there must have been some German lawyers involved in this drafting. Now, the powers of the power of these public enforcement authorities at the level of the member states will have to have the possibility to carry out investigations and as well to provide some sanctions for the companies. So this is quite general. So this is maybe a little that we can say at the moment regarding to will that be effective or not. I think if that is effective or not will depend on the resources that these public authority will have to conduct investigations. And as well as on maybe the sanctions themselves. If I go to civil liability, which is the second mechanism, the big difference again between public enforcement and civil liability is that in civil liability you will have more an active and agency role for the affected individual as well, although in the public enforcement affected individuals will also have the possibility to inform the supervisory authorities. But really the civil liability for me, once again, is really a very important feature of any due diligence law, as it gives an active role to those who are affected by corporate conducts. I just have another slide. I don't want to annoy you. It's just one. I think it's easier because the conditions of liability are quite complicated to understand in the directive. So this, I just wanted to show you more clearly the conditions. So the first element, we can be sure that we will not have a wave of claims. I think this is my opinion with regard to the conditions. So this civil liability provision is described in Article 22 of the draft proposal, where you have two main conditions. The first is that there must be a failure to comply with the obligations, the due diligence obligations, to prevent or end the impacts. And that will require two first questions. The first, do I have as a company an obligation to identify the impact? So I will come back to Article 6. And as you know, in Article 6, well, as a company, you will only have to identify the risk of your own operations, of the operations of your subsidiaries, and of your established business relationships, as was described by Nadia earlier. Now here, I just wanted to make a distinction that should be clarified. You can have a direct and an indirect business relationship. Not really sure what that means. Maybe the European Union will have to clarify this to some point. But first, so if I don't have an established business relationship, well, I'm not supposed to identify risks, so I cannot be then have any kind of liability for what I didn't have to identify. So this is the first problematic, I think. The second is the distinction between very large and large companies. For very large companies, that will include all the human risks. If I understand quite correctly, for large companies, the risk that you will have to identify, this is in Article 6, paragraph 2, you will have to identify only the severe impacts that are related to your impact sectors. So again, very, very limited for large companies. And I think, maybe I'm mistaken, but I think this is how I read the proposal. Please correct me in the round of question later if I'm not correct. So first question will limit a lot. Will I have to identify risks? Once I have to identify risk, then I have two obligations. I have either to prevent it or to end it if it's already occurring. And this is where you have to go back to Article 7 or 8 and say, well, did I develop an implement a prevention plan? I think this is what comes a little bit more from the French law. So if I identify risks, did I implement and develop a plan to prevent that risk? Did I make contractual insurances with my direct contractors? Did I make the necessary investment to ensure that the measure to implement the prevention plan, for example? And in the last resort, did I terminate the relationship or suspend the relationship with regard to the risks that I identified? So this is the first question. First, do I have to identify the risk? And second, did I take the preventive or the measures to end the impact? And this, again, this is very problematic, but this will be not the company that will have to prove that it took all these steps. It will be the claimant. Imagine the affected individual that will have to prove all these elements. Once again, I think this is absurd to require an affected individual to prove that the company did not implement a prevention plan or make the necessary contractual insurances or take the necessary investment to prevent the harm. Well, this is problematic, but at least we have the civil liability provision. Once we have identified this, then we will have a quite difficult causation to establish. This is this causation between this failure to comply with the obligation, the due diligence obligation, and to prove that these failures, so this omission, led to a damage. And anytime we have an omission that has to prove the causation from an omission, we will have to ask a hypothetical question. If the company had taken that measure, would have the damage occurred or not? Which will raise another range of quite difficult questions to establish causation. So we have these conditions of civil liability. I think I just let it here in a very analytical way, and we can discuss this later. I know that Claire wanted to come back on this very complicated Article 22, paragraph 2 provision that deals with the liability for the activities of indirect established business partners. I'll let you tell us a bit more about that, Claire, if you want.
Sure, thank you, Nicolas. And just before I say that, I just wanted to reinforce some of the points that you made that I completely agree with. I think here we have one of the strengths of his proposed directive, in my view, is really that we have a double enforcement mechanism, which is quite unique, because if we look at existing instruments, and Nicolas, you were just mentioning the German law, but we can think about the Norwegian law, we can think about the Dutch Liability Diligence Act. We have laws that rely on exclusively on one enforcement mechanism and administrative oversight. And then the French law on the duty of vigilance is the only example we have of a law that has been adopted in a mandatory human rights and environmental due diligence law that has an associated civil liability provision. And both of these enforcement mechanisms are very helpful. And we can see that from the sort of lessons learned from existing models. If we look at the report for the French government on the implementation of the French law, one of the recommendations that is made is to have a public authority to supervise the compliance with the law and to clarify some of the concepts and requirements of the law that there is still some uncertainty around. So having a public enforcement authority, a public supervisory authority is useful and can play an important role in ensuring compliance. And we see in the directive also the power of this authority that can, in particular in terms of investigation, in terms of sanctions that should be linked proportionate to the turnover, etc. But on the other hand, access to remedy, putting the right holder in the center is absolutely crucial, and you just do not get that with a public enforcement authority. So for that, you do need a civil liability provision, which also plays a double function in the sense it also helps ensuring compliance with the law, as well as having that access to remedy function. So I think these two enforcement mechanisms are very important. Now, in the civil provision, civil liability provision that was very clearly explained by Nicolas, here we have an approach that is relies basically on a fault-based regime, very much in line with the what was envisaged in the French duty of vigilance law, and of course the fact that the burden of proof is not reversed, as Nicolas was referring, is problematic in terms of making sure that access to remedy is effective for individuals. Then we have the paragraph 2 of Article 26, so a sort of due diligence defense that is sort of quite limited in a way. Here, one thing we've sometimes heard or read that this provides a sort of safe harbor. And I would like to nuance that a little bit. I don't think that's the case. What it does, what Article 22, paragraph 2 does, in my view, is provide a defense that companies can use, first of all, only in relation to indirect business partners with whom they have an established business relationship. And in particular, it provides that the company shall not be liable for damages caused by the activity of such a partner, where the company has sought contractual assurances in relation to compliance with its codes of conduct, and as necessary, when the company has requested a prevention action plan or a corrective action plan, depending on what the case might be, with its codes of conduct. But it also requires the company to ensure that to have in place appropriate measure to verify compliance. Now, the over-reliance on these contractual assurances, on these measures to verify compliance, so basically we're talking about audits, social audits, we're talking about certification schemes, in itself is problematic. And we know from experience that contractual clauses, audits, certification schemes may be a helpful part of the due diligence process, but by no means can they be on their own exclusively the due diligence process. There need to be other measures in place. There are very serious gaps with these types of measures. However, what I do see in Article 22, paragraph 2, is words like appropriate, words like reasonable. So it says unless it would be unreasonable in the circumstances of the case to expect that the action actually taken, including, of course, as regards to verifying complaints, would be adequate to prevent, minimize, bring to an end, or mitigate the adverse impact. And so I think here the concept, the reference to the concept of reasonableness and the appropriateness, which we find sort of in the reference to Article 7.4, so there's lots of, in Article 8.5, so we have many references there to cross-reference. Here again, we go back to the understanding of due diligence as a standard of expected conduct, which I mentioned earlier, which is in line with the UN guiding principles. So really, in my view, they prevent that provision from creating a sort of risky safe harbor whereby companies that simply have contractual clauses in place would simply be able to escape liability. Rather, what the judge will need to look in a concrete case, look for and scrutinize will be the adequacy of relying on contractual clauses, on verification, on auditing schemes in the circumstances of a given case to prevent, to mitigate, to bring to an end the adverse human rights and environmental impacts. And I would argue that in the very majority of cases, if not all cases, these will not constitute by themselves adequate due diligence. And so they will therefore not allow a company to rely on that defense to escape liability. And I will stop it here.
Many thanks, Claire, and perhaps I will just shortly abuse of my position as chair to add some comments, because I definitely agree with Claire that this over-reliance on contractual assurances is problematic, and not only indeed in relation to civil liability, but also in general as a means to prevent negative impacts from happening. We see this under Article 7. I'm a bit perplexed indeed about this article because it seems really to focus the prevention effort that should be required from businesses on the contractual aspects, on seeking contractual assurances. It appears that prevention is treated solely in the context of contractual relationships, or in contexts in which contractual clauses can perhaps make an impact, but we know that there are many other many contexts in which contractual assurances do not suffice. For instance, when the adverse impacts arise from the impacts of mining or from business relationships with foreign governments. I don't see how this over-reliance on contractual assurances could in itself exhaust the theme of prevention. And this is also reflected then in Article 8, where the proposal says that where the adverse impacts cannot be brought to an end, then companies should be required to take actions, including where relevant, neutralize the adverse impacts or minimize its extent, including by the payment of damages to the affected persons and of financial compensation to the affected communities. Of course, it says including, so it's not an exhaustive list of possible remedial actions, but at the same time, I think this formulation uncovers a bias in favor of financial compensation as a means to remediate harm. And we know very well that in some cases, once again, in the mining, in the extractive context, when communities are displaced, it is not just enough to provide financial compensation. Many other types of reparations might be necessary. So I think in this respect, the scope of prevention and the scope of remediation in general are quite narrow in this proposal, and I find it problematic, especially in the light of the fact that involvement of affected stakeholders is really marginalized in the proposal. We know that the European Parliament had dedicated an entire Article 2 stakeholder involvement. It was still not up to standard. It was not completely in line with the international standards on stakeholder engagement, free prior informed consent, and other relevant international standards, but at least it put a very relevant focus on the involvement of stakeholders. Whereas, once again, in this proposal, there are very few provisions relating to this, and they are worded in very weak terms. For instance, in Article 6, in relation to risk assessment, companies shall, yes, but only where relevant, also carry out consultations with potentially affected groups to gather information on potential adverse impacts. And also in Article 7, we find a reference to stakeholders, but once again, only where necessary due to the nature of, or complexity of the measures required for prevention, then companies are called upon to put in place, to implement a prevention action plan. And in this respect, then the plan shall be developed in consultation with affected stakeholders. There is no mention of consent that is actually required under international law in specific circumstances in the context of large-scale projects significantly affecting communities. So I would say that on these aspects, the proposal clearly falls short of international standards. But I would really love to hear on this and on other issues from our audience. So I will now open the floor to questions, if there are any. And of course, you can raise your hand or take the floor, or even write in the chat, but I don't see any questions in the chat for the moment.
Whilst we're getting questions, can I just make a very brief addition to what you were saying, Chiara, which I think was really important on the stakeholder and force engagement, which is sort of very flappy in the directive. And I think that's particularly problematic because, again, if we look at the lessons learned from existing examples like the French duty of vigilance law, the lack of stakeholder engagement was precisely seen as one of the main pitfalls of the implementation of the law in practice, and where companies are not doing very well in practice. And of course, in the French law, stakeholder engagement is encouraged, but is not required, with the exception of the putting in place the mechanism, the whistleblowing mechanism. So I think that that's an important point that you raised there.
Thank you very much, Claire. And now I actually see several questions and comments. First of all, Lucas.
Thank you, Chiara. Thank you for organizing this seminar. It was very informative, and thank you for to the panelists as well. And also, it's a bit obligatory, but I'm happy to see a lot of familiar faces here today, and I'm very happy this is being engaged with so extensively. Although I have a mountain of questions on the details of the proposed directive, some of which have already been answered by the panelists, I wanted to give more like a general observation and ask for comments. And that relates to what Claire just said on stakeholder engagement. My impression is that, and that this didn't start with the directive, it's already very been present in the, some of the national due diligence laws, is that we're very slowly moving away from what triggered the rise of the whole idea of business human rights in the first place, and that is the having the rights holders at the wheel, basically. This is what distinguishes business human rights from corporate social responsibility. Who drives the process? Who sets the demands? Who sets the standards? And if I look at this directive, and you can see it in a lot of different ways, you can see it in the lack of stakeholder engagement identified by Claire. You can see it in the very weak remedial lag of the due diligence obligations. You can see it in, I mean, even when there is when there are liability provisions, it's still sort of, I'd say, relatively flat. But you can see it, I think, most of all in how, compared to those, or compared to the lack of attention to stakeholders, how deeply it engages with the corporate processes, how deeply it engages with corporate governance. Now, of course, that's a very intentional choice that we can discuss whether that's a good or a bad thing. I mean, I think to an extent it's good. I think it's good that we have very specific obligations, as I think Nicholas already pointed out very persuasively, but we are really in danger of focusing so much in the inner workings of corporate groups and the inner workings of supply chains. I mean, it's not even called a human rights instrument anymore. We're literally moving from human rights to sustainability. So how much of this is still within what we, I think, collectively would consider a business and human rights paradigm? I think that's my question.
Many thanks, Lucas. Perhaps I will also take Ben's question/comment, and then I will give an opportunity to the panelists to reply.
Yeah, so the nature of my question is a bit similar to Lucas's, and it's kind of a comment with a call for sort of feedback on what you think of it. Thank you for setting this up. This is really helpful because I haven't actually had the time to go into this in depth, so it's really helpful to have this summarized but you've really looked in depth in it, and it's really helpful to kind of understand where this directive is coming from. And I would like to echo Lucas's comments that it's fantastic to see so many people engaging with this. So for those of you who don't know me, I'm Ben, and I'm doing my PhD on grievance mechanisms, on company grievance mechanisms. So I have a very niche look at this from a grievance mechanism standpoint and what it says about company grievance mechanisms. And I was comparing it to the European Parliament's proposal from a couple of years back, and the way that the European Parliament did it. And just for the purposes of background, what I see with grievance mechanisms so far is that grievance mechanisms have a huge variety of purposes, from compliance to engagement to giving community members a voice to relationship building. They're rarely set up to provide explicit reparations, but in human rights circles, we often still think of access to remedy as reparations. And I'm increasingly seeing in sort of the OHCHR's approaches, access to remedy can be anything from before the impact even occurs, that can be access to remedy, and we see access to remedy extending over a variety of things. And the way the European Parliament approach took that was they had one article on grievance mechanisms, and they had another article on sort of remedial measures by the company, and that the company could provide reparations through their grievance mechanism, and if so, this is what reparations should look like. And then also, the company has a responsibility to be engaged in remediation processes. Whereas, if I understand it correctly, and your presentation seems to confirm this, the approach here is really that the company should be engaged in prevention. And when we look at remedial measures, that's an obligation of the sort of supervisory bodies, the member states. There isn't really a clear standard here that the company should be engaged in remediation itself. And when I look at the article on grievance mechanisms, which are not even called grievance mechanisms in this proposal, they're called complaints procedures in Article 9. Basically, the only thing that a company is required to do is have a process which you can come to, any external stakeholder can come to, can raise a concern with a member of staff, and then it's entirely up to the member of staff how they will approach that. So I'm thinking, what's the minimum requirement you need to have a grievance mechanism under this directive? It's an email address. Which you can email a member of staff to come back to you, and they will listen to your concern, and then they will decide how to respond to that, which is a very low standard of requirement for a grievance mechanism, even compared to the most relaxed standards I've seen in multi-stakeholder initiatives and industry initiatives. So that's just something I wanted to raise and maybe get your feedback on the importance of that.
Thanks, Ben. Very interesting insights. I see two other questions, but please keep them and I will come back to you. First, I will give the floor to the panelists in case they have comments or replies. Perhaps Nadia, would you like to start?
Yeah, I can start. I mean, I agree with the comments that have been done, that have been made already. It is called sustainability. It's in the title of the directive. I think this is telling. I agree that it's the term human rights is not in the title. Yeah, I think it is telling, definitely. I think it's in line with the very small role played by rights holder in this proposal, as been mentioned both by Ben with regards to grievance mechanisms, something that I have to say I had overlooked while reading the directive. But you're right, that is actually very relevant and very telling, I think. And also, as was just said, the fact that consultations are seen as something that should be done where relevant. I think this is all in line with this approach that is very corporate indeed, for lack of a better word. Maybe that was to be expected, given that this is coming from the EU Commission. It's true that if you read this, when I read this proposal as primarily an international human rights law person, let's say I'm not in my comfort zone with reading this. It's very difficult to recognize established principles on remedy, on human rights, yeah, I don't know. There's no question really there, but I agree with that assessment of it. I think it was inevitable, but yeah, I agree with that, let's say, comment.
Thanks, Nadia. And Nicola, did you have a reply? Yes.
No, just that I agree, and I was just thinking, well, this is a good topic for a scientific article that Luca and Ben. I really I would very happy if you can write more about this, because I'm just when you were talking, I was just looking in which articles affected individuals are really part of this directive, draft directive, and yeah, so the company basically has an obligation to consult when it does the preventive action plan. I think this is one. This is Article 7. In Article 8, when there is damage, then there is a financial compensation that should be made to affected individual. And then you have this Article 9 with the complaint procedures for individuals. That seems very weak. And then finally, affected individuals have also the possibility in Article 19, I think, to refer to the supervisory authority. So this is how affected human being have a place in that. But I would be very happy if you would criticize it or really show the shortcomings of these individual engagement to make it a more human rights instrument than a corporate accountability instrument. So I think that would be a very good topic for an article.
And if I can perhaps just add to some of the points I just made. First of all, thank you very much, both of you, and thank you so much, Ben, for this extremely insightful comment. I'm not suggesting to have an in-depth conversation about this now, but I think that conversation needs to be at some other point made on what I wonder, and I completely take your point about Article 9 and its limitation. But what I wonder, and here it's a question I'd like to pose you again, maybe some other context, we can have a chat about that. Is would it be a good thing to go much further in terms of asking companies through its own processes to remedy? Like, I would be worried about the privatization of remedy. So that's just a comment I'm putting out there. I am very in favor of civil liability access to remedy through the courts. I'm a little bit worried about the privatization of justice being left in the hands of the company. So that's just, but again, I don't have an answer. It's a question I put there. On the point by Lucas on the terminology, just sharing some of my experience here in Portugal. A few months ago, we had every day on the news the issues of decent, or shall I say, indecent work of seasonal migrant workers in the agricultural sector in the Alentejo. And it was in the news every day, but it was never framed as a human rights issue, never. The terminology really matters. When engaging with companies, for instance, here in Portugal, if I tell them about business and human rights, it doesn't mean anything to them. If I tell them about sustainability, they're interested. And so I think it's sort of probably strategic of the Commission to go, because the terminology is fashionable. You speak about terminology, you speak about sustainability, sorry. So one of the battles I'm trying to fight very hard is when talking about sustainability, reminding everyone and reminding companies in particular, we look at the SDGs, we look at the preamble of the SDGs, and it says very clearly that all the SDGs and all of the targets are here to realize the human rights of all. So human rights are at the absolute core of sustainability, and you cannot claim to be sustainable if you are not respectful for human rights. So it's sort of it's sort of inbuilt in that concept of sustainability, or should be, at least. Maybe it's not, but it should be.
Thanks, Claire. I definitely agree with you. I think from this point of view, perhaps it's good to acknowledge that at least in the annex, we have listed also a number of, for instance, environmental protection instruments, such as the Convention on Biological Diversity and its Nagoya Protocol, that clearly show the link between environmental protection and human rights, and they have inbuilt certain mechanisms, such as the involvement of indigenous communities when a country wants to grant access to genetic resources to companies or foreign countries. So in this respect, if the directive will be effectively interpreted in the light of those international standards that are listed in the annex, then there can be a truly holistic approach to due diligence. But I agree with you that the human rights perspective is not sufficiently built into the actual text of the directive, and I'm afraid indeed it won't fully succeed in injecting this human rights perspective into the public debate as well. So we have a couple of hands. Actually, now we have 3, and we also have a question in the chat. So I will try to give the floor to everyone very briefly. Please keep the questions as brief as possible and on point. Let me first of all read a question that I had seen in the chat by Chiara Morfea, who is a PhD candidate at the University of Bergen, and she would like to ask what will be the role of this directive, in your opinion, in effectively extending the due diligence requirements to the financial sector? So this is the first question. Then we have Christina. Please, Christina, you have the floor.
Yes, thank you very much, Chiara. And thanks for all the very useful interventions and questions. On the point that human rights language is not very identifiable, I think we should remember that initially the directive was supposed to be about human rights due diligence and was then extended to also cover environmental issues. And hence, I guess, the title sustainability, corporate sustainability due diligence. So I think we should take that parcours into account, that the idea was also to cover other issues. But my concrete question is that there's also quite significant text on climate change, and I haven't read any article or heard any seminar regarding this directive highlighting the relevance of this directive also to increase business action on climate change. And I was wondering if maybe you, Chiara, since you have written about climate change and due diligence, could give your views on whether you think that this will make any difference or have any impact, considering that well, climate change is the most significant impact on human rights, and that we are really in a climate emergency. Do you think that this directive will make a difference there? Thank you very much.
Thanks, Christina. And I will now give the floor to Sune.
Yeah, hi. Thank you for a great webinar, and it's great that you're so concerned about the due diligence directive. And so am I. I worked 25 years as a corporate international lawyer on business and human rights. 10 years before that, only as a international corporate lawyer, but I work very closely with Gianluigi in formatting the guiding principles from 2005 to 2011 as well, and are implementing every day due diligence with businesses primarily out of Denmark. And I'm very concerned, touching to Claire's point of view about the terminology used. So I'm quite concerned, although I can see all the companies I assist, they will fulfill the requirements from the new directive. So unless in relation to how they deal with business relationships, but I wonder why we could we have more research into looking at the definitions on human rights, respect for human rights that we have in the guiding principles, up against what's actually in the directive. A few points I will raise is the use of adverse impacts on human rights. So the guiding principles are very clear that businesses cannot violate human rights. There's one exemption, and that's principle 23.c, where you can look at gross impacts as legal compliance. Hence, states violate human rights, businesses cannot violate human rights. Yet, again, the directive proposed with the annex that now we are suddenly looking at companies violating human rights, and it also sneaks into the directive itself a few times. That's a turnoff for business. We know that business need to manage adverse impacts on human rights. We want to know what the risks of impacts are, and we want to show how we manage them. And we all businesses have risks of adverse impacts on human rights, even if they operate in Europe, as we also heard from Portugal. But that's the same. I mean, at least 17 human rights are at risk for any Danish operation where we conducted their operational level human rights impact assessment as part of due diligence. So that part of the terminology is, of course, challenged. The next part is the complete conflation between when you cause or contribute to adverse impacts. This is foundational principle 13a, and where you are merely linked to adverse impacts, where the guiding principles are pretty clear that you should not provide access to remedy where you are merely linked to adverse impacts. And the whole liability scheme here conflates those two, so say, management streams as we see them with businesses when we implement, and creates civil liability when you are merely linked to adverse impact, even without describing what kind of impacts we are talking about, considering that all companies have risks of adverse impacts on at least 17 of the 48 human rights in the International Bill of Human Rights. So we see quite a few challenges with the due diligence directive diverting from the definitions that Gianluigi had 6 years to work through and had very good reasons for proposing internationally. I think the big challenge is that we haven't really seen documentation of due diligence from any business yet, I would claim. I mean, the few human rights impact assessments we have seen in the public sphere are not aligned with the standard. So if we would have, so to say, more focus on trying to find the better practices of companies that actually conduct operational level human rights impact assessments regularly, as they're supposed to do according to the guiding principles, then I think we would have a much better understanding of what the business side of this looks like. If we are introducing civil liability for adverse impacts that we are merely linked to, then I will stop my present career more as a consultant than an attorney, and then I will start suing all companies around me. I see a huge. I do not completely concur with Nicholas. I think there will be a heaven for lawyers going forward if we open up for these kinds of trials. and it will take a long time before we define what's actually the content of the various national regulations to implement this directive. All in all, I'm very happy about the directive. I think it needs much more to align with the definitions that John Ruggie cared so much for putting out in a very precise manner, and they are pretty precise in the directive. Thank you.
Many thanks, Tune. And we also have a question or comment by Daniel.
Yeah, thanks so much also from my part for organizing this. This was a great introduction for my part, because I have had not a chance yet to study this in detail. I have a bit of an overarching comment about some of the challenges we face here, relating to what Nadia said about sort of the established business relationships and the danger that then companies may opt for non-established supplier relations, but also to what Chiara said about consultation and what Claire said about privatization of remedies. To my mind, these problems are not specific to this directive, but older, and they have to do with our overall project, right? About sort of the attempt to effectively implement at a global level human rights commitments by using the private sector, basically, right? And using private sector techniques, corporate governance, management, and so on. And of course, I mean, it's a mixed bag. I mean, there are achievements and there are challenges. On the side of the challenges, I mean, I think it's not just a question whether human rights are at the forefront, but also what we mean by human rights for the purpose of this project, right? Sort of, in a way, we see a proceduralization of human rights here at a very thin level, of course, with these. And of course, we need to accommodate the fact that we entrust increasing responsibilities to private, democratically not accountable actors here, and so on and so on. I think what I wanted to say is that, I mean, I'm looking here forward towards an implementation at some point of whatever form of the directive at the national level, where there will be some leeway for governments. I mean, what strikes me as important is that we're working towards sustainable supply chains, and you find that in various parts of the directive, and that should guide our interpretation of certain other provisions. For example, with regard to established commercial relationships, I mean, there's an argument to be made that to have a sustainable supply chain, companies should only have established business relationships, right? Rather than the other way around. So there shouldn't be an exit here towards short-term, unreliable contracts and supplier relations. I think same with consultation here. I mean, on the one hand, there is, especially when we're looking at the non-existent here, free and prior and informed consent. I mean, that's not just a procedure, it's a substantial right. And that's something we tend to lose in our debate sometimes. At the same time, there's a question whether companies can meaningfully comply with their duties under this directive if they do not, at the same time, work towards an effective engagement of stakeholders, right? So again, I mean, the general telos of the directive drives here in a certain direction, maybe even beyond of what is now required. And lately, with regard to the privatization, I think that's one of the most challenging aspects in remedies or otherwise, because I mean, we do need to think in what sense we get like a democratic public back into that process, right? And there, the danger here and elsewhere is not just a managerial approach, but also this focus on efficiency or effectiveness, right? Effectiveness is important, but it's not at the heart of it at the end of the day, right? Because we first need to discuss what we mean, what we want something to be effective for, talking about financial compensation rather than a meaningful remedy and so on. So my basic point is, I mean, let's also look at what the project is about and what it should be for, and appreciate sort of what the directive does and doesn't in this regard in our challenges. Thanks.
Many thanks, Daniel. I will give just a telegraphic answer to Christina about climate change. Of course, it is very positive that climate change has been included in the directive. In Article 15, companies might, in certain circumstances, be required to include emission reduction objectives in their plan, specifically when it has emerged that climate change is or should have been identified as a principal risk or a principal impact of the company's operations. This is positive. However, the directive is quite vague on, for instance, which types of emission scopes would fall under this requirement. So should companies be required to cut their scope 1 emissions? Should they take steps to also reduce the scope 3 emissions, as we have seen in the judgment against Shell delivered recently in the Netherlands? This is not clear, and also there is no mention of offsets, like carbon offsets. Would that be would it be enough for a company to conduct climate due diligence by through carbon offsets, as opposed to concretely reducing their emissions? It is not clear what it means to comply with this climate due diligence requirement under the directive. So more discussion is needed on this. But I will quickly give the floor to the panelists, perhaps starting with Nicolas. Please be brief because our time is almost up.
Okay, no, just two comments. I think the first remark was on financial undertakings. I think it is, I have nothing to say, just that there is a provision that says that companies include financial undertakings, which means this is defined in Article 3, paragraph 4, I think. It means like banks, pension funds, institutional investors, so very interesting. But however, in the risk that should either, and this will apply to very large companies, so they will have new due diligence obligation. Now there is a provision in Article 6, paragraph 3, regarding to the due diligence, the risk that these financial undertakings must identify, which, to be honest, is not really clear to me. It just says that they shall, these due diligence obligations shall be carried out only before providing that service, so lending money or providing money. This must be definitely clarified, and this is certainly not aligned with the OECD guideline, I think. And the other comment I wanted to make with the problem of definitions, I think we have to agree and we have to highlight that this concept of contributing, direct causation, contributing to, and direct link doesn't exist anymore. Is not reflected here. So the UNGP is more like a risk-based approach, maybe more than the corporate directive, which creates some uncertainties. But I think to me, we need to align with the UNGP, and the Commission has done a good work on this, I think. But we need to find a pragmatic compromise at the end of the day, I think.
Thanks, Nicolas. Nadia? Do you have any?
Yeah, I was just listening with great interest to everybody's comments and questions. Just to reply perhaps to Suna on the question of the text of the directive sort of drifting away a little bit from the UNGPs in terms of what is expected from companies carrying out a due diligence process and the practical difficulties around this. I think this is, I'm sure also from a practitioner's perspective, this is a valid point that when companies actually need to do the work, there needs to be some clarity. But I also want to point out that we've had the UNGPs for 11 years, and that, yes, this new proposal, and let's see if it gets adopted, but yes, it is different. I think in many ways it is stronger and demanding more of companies, particularly of European companies. But this is the deal. I mean, this is a piece of legislation meant to further human rights and environmental protection. So that it's different from the UNGPs is not only, let's say, expected, but I think that's very positive. Now, if that's going to make it more difficult for companies to do the job, great. We want it to be difficult because it is like what's at stake is human rights and environmental issues and climate change. So it was never going to be an easy task to undertake. I'm really delighted to see this proposal, to see the EU taking action on this. We can debate whether it's strong enough, but it's definitely stronger than what is recommended in the UNGPs, for the very fact that indeed with this directive it's going to be required and not just recommended. That alone is very important. So I agree, it is going to be more difficult. I think there's no sugarcoating this for companies when approaching them. There's no point telling them that it's all going to be the same thing. It's not. It's meant to be different. That'll be my final words.
Many thanks, Nadia. Then I will leave the floor to Claire for the final comment.
Thank you. Very, very briefly, 2 points. On the climate change, as raised by Christina, I think one important limitation is the due diligence obligations in the directive do not actually extend to climate change. And we see that in Article 29 on the review of the directive, where it says Article 4 to 14, so basically all the due diligence articles the directive should be reviewed to see if these articles should be extended to adverse climate impacts. So that basically implies that climate impacts are not included in the due diligence expectations and obligations. And I think adding onto the limitations pointed out by Chiara earlier that are linked to the article, the dedicated article to climate change, I think this is an important limitation. And I'm not exactly sure what the rationale is behind that. And then the last point is on the contributing and directly linked distinction. I agree with what was said by Sini and by Nicholas, that it is clearly not, doesn't appear in the directive anywhere. I wonder, this is my own take on it, might not be the right one, but I wonder if, because the directive does expressly refer to the UN guiding principles and international standards at various places, one could consider that it is therefore implied that liability would be limited to situations of where the adverse impacts are caused, or where a company causes or contributes to adverse impacts, and not in situation of direct linkage. But this is just my guess. And I will stop here. Thank you very much again, Chiara and Nadia.
Many thanks for joining us and for being so active. There is still a lot to say about this proposal, so but we are sure that this will, by all means, it will not be the last event organized on this theme, so we will resume the conversation soon. In the meantime, if you still have time after this webinar, there is a webinar ongoing concerning business conduct in times of war. It is organized by the University of Kharkiv in collaboration with the Polish Institute for Human Rights. I put the link in the chat if you want to register and take part in the event. Thank you very much for joining us, and let's continue the conversation soon. Thanks. Bye-bye.
Bye-bye.
Thank you. Bye.
Thanks, everybody. Bye-bye.